Am I audible, ma'am? Am I audible?
You are audible, and then
Okay, ma'am. Thank you.
I am audible too, right? And I'm
Yes.
not too loud.
Yes, ma'am. Yes. You're fine. Your voice is fine.
Okay, let me try.
We'll just wait a few more. Namaste. Namaste to everybody and a very warm welcome to you on the second day of the workshop, the IKS TKDL workshop on traditional knowledge, intellectual property and people's rights. We are extremely privileged again to have with us Dr. Vishwajanani Satyagiriji, who's the director of the CSIR TKDL organization. And today's speaker is going to be Dr. Anil Kumar, who is a senior scientist at the CSIR TKDL. So I'd like to just inform you that what we typically do is that there will be a talk for about 45 to 50 minutes. And after that, we'll take your questions. So there were some questions that were left out yesterday. So I sincerely hope everybody's attending and that please feel free to pose those questions. We'll try and address them today. We are also joined by Dr. Vijay Lakshmi Asthanaji, who's also a senior scientist at CSIR TKDL. So look forward to your active participation. Please be behind your screens and listen to these valuable gems that will be sent your way. So with these few words, over to you, Anilji. Namaste. Anilji, we can see your slide. Over to you. Yes.
Yeah, am I audible, ma'am, now?
Yes, please. Yes, yes.
Sure. So today in this workshop, we are going to discuss about the fundamentals of intellectual property rights. And just give me a moment. Let me share it again. There was some issue, I think. Yeah, is it visible now? Is it visible, ma'am?
Yes, it is. It is.
Okay.
And we can hear you also.
Sure. So this is the second day, and we are going to discuss about the fundamentals of intellectual property rights.
Yeah,
So,
and then just give me 1 minute before you go ahead. I will, because some of the participants wanted us to kind of give the outline of the workshop and the presentation. So I'll just interrupt you for a few seconds. So to all the participants, namaste and good afternoon. Thanks, Anuradha, for being with us through the workshop. So the way that we have kind of structured the workshop is to kind of give you a glimpse of, whatever our Indian traditional knowledge is, the vastness of it, just to kind of give a feel, about the diversity as well as the uniqueness of the traditional knowledge, so that this becomes the basis for further research by the researchers and even for, as a material for teaching by the teaching faculty. The second day of the workshop is on the, Anil, you go back to your slide, this slide number 3. Okay. The second day of the workshop, second day of the workshop is on the fundamentals of the intellectual property rights. Here we are going to be very broad based. So we are going to give you an understanding of the different types of the intellectual property rights, such as patents, trademarks, copyrights, geographical indications, plant varieties registration, and so on and so forth. What constitutes the patentability, what constitutes the rights to gain trademark, and all those details will be discussed today. The day 3 would be focused on traditional knowledge. So as I mentioned yesterday, we're going to talk about both the defensive and positive protection of traditional knowledge. Along the same lines on the traditional knowledge, the day 4 will be focused on the ethical aspects of handling traditional knowledge, especially when it is the traditional knowledge belongs to people. The people's rights needs to be respected and observed. Day 5, again, it's just going to give you a glimpse of, what are the TK inspired innovations, and we will be giving both national as well as international perspective on what constitutes TK inspired innovations. And this particular day, that is day 5, we will close the workshop with an assessment of the participants. A MCQ based test will be given, and Mr. Anil, my colleague, will be administering this particular test, and he will be providing details of this on day 5. So back to Anil. Sorry for interrupting you, Anil. So this is the way we have structured the workshop, and we look forward to, kind of interacting with you on this platform as well as through email, as I had mentioned yesterday.
Thank you, ma'am. To take this thing forward, as ma'am has discussed, today we are going to, today is the day 2 of this workshop, and we are going to discuss the fundamentals of intellectual property rights. So when we talk about intellectual property rights, these are the intangible rights that that have been given to the innovators and the authors of the intellectual creations. So to discuss it, let us take an example of, let us discuss the cycle of creation. So when we talk about intellectual creations, it requires a lot of skill, intellectual skill, and a huge amount of investment also. So to secure the investment that has been made on these creations, these are the rights on these creations must be secured in a proper way under legal instruments so as to reap out the benefits from these creations. And once we'll reap out the creations, that exploitation, the economical exploitation of these creations will lead to further further development, and this is the cycle of the innovation that happens. And this is how we lead to the research and development of new items which are the subject matter of intellectual property creations. So when we talk about intellectual property rights, there are certain kind of various instruments when we talk about intellectual property rights. And these rights include copyrights, patents, trademark, industrial designs, GIs, plant variety protections, apart from some few additional instruments of IPRs. So when we talk about copyrights, these rights are given to the authors of literary and artistic creations. And the rights are also available to the producers of musical works and cinematographic films. Likewise, when we talk about inventions, these, the inventions are protected under the acts, the act, which is the Patents Act of the respective country. And likewise, when we talk about the certain marks which are being used for the products, these marks are being protected under Trademarks Act. So likewise, we have Industrial Designs Act, which protect the legal, it gives the legal rights for the ornamental and aesthetic aspects of articles. So likewise, we have geographical indications. So these are the rights which are given for the qualities and reputations and other characteristics of goods which are ascribed to the geographical origin. So this is, these indications are directly linked to the geographical indication, wherein certain kind of reputation and goodwill is established by those products. Likewise, for new plant varieties, we have Plant Variety Protection Act. So the rights are being given to the breeders, farmers for the protection of new plant varieties that they have developed. So now we'll discuss these instruments in detail. So first of all, we'll talk about, yes, ma'am.
As you move forward, you use both Hindi and English to convey the same matters. We may exceed a little bit of time, but I think based on the request by many people, we can be bilingual.
Sure. So when we talk about inventions, basically the inventions which are technological developments, these are protected by patents. तो एकस्वाधिकार जो है, पेटेंट्स को हिंदी में हम लोग एकस्वाधिकार बोलते हैं, और these patents are being given for either for a product or a process. So ये पेटेंट्स जो दिए जाते हैं, ये आविष्कारों के लिए दिए जाते हैं, और या तो हम कोई नया कोई प्रोडक्ट डेवलप करें उसके लिए, या फिर हम कोई नया प्रोसेस डेवलप करें. ओके, तो these inventions, they deal with two kind of two categories. One is the product and another is process. And basically these the product or process that we develop must lead to a solution. So there must be a unmet need. Okay, and to solve that unmet need, we must arrive at a solution that may be a product or process. So in case we are doing that and that product is it fulfills the requirements under the Patents Act, then it is a patentable subject matter and it can be protected under Patents Act, subject to the fulfillment of other formalities that are prescribed under the law. तो जब हम बात करते हैं the purpose of the technological innovations, so patents, if you see, the inventions that that are being undertaken, they require a lot of effort. They require a lot of investment, and they require a lot of skill from the innovators. Okay, so until or unless we are not giving protection on these inventions to these innovators, then they will not disclose properly the technological innovation, and in case these technological innovations are not disclosed, then it is, I mean, the chances of developing that innovative product further is very less. So there is a kind of arrangement which has been given under this law, wherein you have to disclose the invention to the fullest, and you get a protection for a certain period of time. So for 20 years from the date of filing of patent, you get the protection provided you disclose the invention to the fullest, so that a person who is skilled in the art can work on it without any additional efforts. तो जब हम लोग पर्पस की बात करते हैं, तो पहला पर्पस तो टेक्नोलॉजिकल इनोवेशन है इसमें, और दूसरा है कि जो इन्वेस्टमेंट और स्किल्स का जो हम यूज करते हैं ये टेक्नोलॉजीज बनाने के लिए, उसमें फेयर रिवॉर्ड्स, उसका जो इकोनॉमिकल इन्वेस्टमेंट है दैट शुड कम टू द इनोवेटर्स। तो ये 20 साल के लिए इसके राइट्स दिए जाते हैं, प्रोवाइडेड यू फुलफिल ऑल द क्राइटेरिया, है ना। तो उस क्राइटेरिया में एक पहला चीज है, यू हैव टू डिस्क्लोज द टेक्नोलॉजी, आई मीन द टेक्नोलॉजी टू द फुलेस्ट, सो दैट एक प्रॉपर जो इनोवेटर है उस फील्ड में, वो बिना किसी एडिशनल एफर्ट के 20 साल के बाद उस टेक्नोलॉजी को वर्कआउट कर पाए। ओके, एंड व्हेन वी टॉक अबाउट द रिक्वायरमेंट्स, पहला तो है कि जो इनोवेशन है वो या तो प्रोडक्ट हो या प्रोसेस हो, और इट कैन बी अ कॉम्बिनेशन। हालांकि एक पेटेंट में अंडर द लॉ ऑफ यूनिटी एक ही टाइप का इन्वेंशन जो है वो पेटेंटेबल है। दूसरा, जो पेटेंट ग्रांट होता है दैट इज गिवन, इट हैज टू फुलफिल द रिक्वायरमेंट ऑफ नोवेलिटी, ओके, एंड इन्वेंटिव स्टेप, एंड इट मस्ट बी इंडस्ट्रियली एप्लीकेबल। इसका मतलब ये है कि जो टेक्नोलॉजी है जिसके लिए पेटेंट ग्रांट किया जाएगा वो नोवेल होनी चाहिए, इट मस्ट नॉट बी ऑब्वियस, ओके, वो ऑब्वियस ना हो, और उसका इंडस्ट्रियल एप्लीकेशन हो। सो दीज आर द 3 एसेंशियल इंग्रेडिएंट्स दैट आर टू बी प्रेजेंट। और ये जो टेक्नोलॉजिकल इनोवेशन है, अगर ये इन तीनों कंडीशंस को फुलफिल कर भी ले, तो सेक्शन 3 में जो कुछ लिस्टेड इन्वेंशंस हैं वो ना हो, क्योंकि अंडर इंडियन लॉ सेक्शन 3 में कुछ कैटेगरीज ऑफ इन्वेंशंस हैं जो हालांकि इन्वेंशंस हैं बट दे आर बार्ड फ्रॉम रजिस्ट्रेशन, सो दे मस्ट नॉट फॉल अंडर नॉन पेटेंटेबल सब्जेक्ट मैटर। तो अगर आप ये रिक्वायरमेंट्स पूरी करते हैं तो यू विल गेट अ पेटेंट। So if you see the example, one is this cycle, which is which was innovative at that time when it was filed. Or second जो example है, that is this bottle opener. So it has a different way of opening. So that's the reason there was requirement of, there was a need to have a proper functioning, proper functional opener जो उन्होंने fulfill किया, और इसको पेटेंट ग्रांट हुआ था 1939 में। However, आज अगर इन दोनों इन्वेंशंस को हम देखें तो दे आर कंप्लीटली ऑब्वियस, और वो नोवेल भी नहीं है बिकॉज दे वर डिस्क्लोज एट दैट टाइम व्हेन दे वर फाइल्ड। तो जब हम पेटेंट सब्जेक्ट मैटर्स की बात करते हैं, तो पेटेंटेबल सब्जेक्ट मैटर जो हैं दे कैन वेरी फ्रॉम apparatus, device, machines, they can be chemicals for industrial application or domestic applications, they can be drugs, they can be food or their compositions। हम लोग बायोलॉजिकल प्रोसेस जो ह्यूमन इंटरवेंशन से हम लोग इनोवेटिवली डेवलप करते हैं उनको पेटेंट करा सकते हैं। हालांकि बायोलॉजिकल प्रोसेस जो नेचर में एग्जिस्ट करती हैं वो पेटेंटेबल नहीं होती हैं। लाइकवाइज हम लोग बायोलॉजिकल प्रोडक्ट्स को भी पेटेंट करा सकते हैं, प्रोवाइडेड वो एग्जिस्ट, मतलब नेचुरली एग्जिस्ट ना करते हों। ओके, इसी तरह से हम होल लिस्ट ऑफ प्रोसेसेस आर देयर जिनको हम पेटेंट करा सकते हैं। सो दीज आर सम ऑफ द एग्जांपल्स वेयर इन वी कैन गेट पेटेंट्स। जैसा कि अभी हम बात कर रहे थे सेक्शन 3 की, अगर हम लोग पेटेंटेबल सब्जेक्ट मैटर जो है उसको क्वालिफाई कर लेते हैं, ऑल द कंडीशंस दैट आर प्रेस्क्राइब्ड, फिर भी अगर सेक्शन 3 में वो फॉल करता है तो दैट इज नॉट पेटेंटेबल। सो अगर हम बात करते हैं सेक्शन 3 की कि क्या इन्वेंशंस हैं जो पेटेंटेबल नहीं हैं, तो उनमें जो पहली है वो है द फ्रीवियस इन्वेंशंस आर नॉट पेटेंटेबल इन इंडिया अंडर इंडियन लॉ। सो अगर हम फ्रीवियस इन्वेंशंस की बात करते हैं तो एक 100% एफिशिएंसी की मशीन इज नॉट पेटेंटेबल। ओके, सो दैट इज बियॉन्ड समथिंग विच कैन हैपन। सो इसीलिए फ्रीवियस इन्वेंशंस जो हैं वो पेटेंटेबल नहीं है। और इसका हम एक और एग्जांपल लें तो हम ऐसा बोलते हैं कि कोई ऐसी मशीन जो बिना किसी इनपुट के आउटपुट देती हो, अगर हम उसको क्लेम करते हैं पेटेंट्स में, although it fulfill the criteria of novelty or non-obviousness and industrial application, still it is not patentable in India due to this condition which is prescribed under section 3A। इसी तरह से वो इन्वेंशंस जो कंट्रेरी हैं पब्लिक ऑर्डर के, मोरालिटी के, और जो सीरियसली प्रेजुडिस करते हैं ह्यूमन हेल्थ को, एनिमल या फिर प्लांट लाइफ को या फिर एनवायरनमेंट को। तो अगर हम इसमें कोई एग्जांपल देखते हैं तो समथिंग विच इज अगेंस्ट द पब्लिक ऑर्डर, लाइक अगर हम कोई मशीन बनाते हैं फॉर काउंटर फिटिंग ऑफ करेंसी नोट्स, सो दैट इज नॉट पेटेंटेबल बिकॉज इट इज अगेंस्ट द पब्लिक ऑर्डर। लाइकवाइज अगर हम कुछ बायो टेररिज्म के लिए कुछ हम लोग कोई कंपोजिशन या फिर कोई आइटम वी डेवलप, दैट इज ऑल्सो नॉट पेटेंटेबल अंडर सेक्शन 3B, तो उसको पेटेंट ग्रांट नहीं होगा। लाइकवाइज द डिस्कवरी ऑफ साइंटिफिक प्रिंसिपल्स और डिस्कवरी ऑफ लिविंग थिंग्स और नॉन लिविंग सब्सटेंसेज इन नेचर इज ऑल्सो नॉट पेटेंटेबल। अगर हम किसी साइंटिफिक प्रिंसिपल की बात करते हैं एंड वी से दैट इट इज पेटेंटेबल, ठीक है, तो वो भी पेटेंट, उसको भी पेटेंट ग्रांट नहीं होगा, है ना। लाइकवाइज अगर हम कोई नया माइक्रो ऑर्गेनिज्म जो है वो आइडेंटिफाई करते हैं विच ऑलरेडी एग्जिस्ट इन नेचर, तो वो भी पेटेंटेबल नहीं है। लाइकवाइज इफ यू सी सेक्शन 3D, द डिस्कवरी ऑफ न्यू फॉर्म ऑफ नोन सब्सटेंसेज और न्यू यूज ऑफ नोन सब्सटेंसेज आर ऑल्सो नॉट पेटेंटेबल। तो जब हम बात करते हैं किसी ऑलरेडी जो हमें कोई कंपोजिशन नोन है, ओके, और उसका हम लोग जो है एक नया फॉर्म डेवलप करते हैं, जैसे कोई हमने इसका सॉल्ट या फिर एस्टर या फिर आइसोमर डेवलप किया है और वो एनहेंस्ड एफिकेसी नहीं दिखाता है, तो वो भी पेटेंटेबल नहीं है। या फिर किसी नोन सब्सटेंस का हम कोई एक उसका कोई नया यूज हम लोग आइडेंटिफाई अगर कर लेते हैं तो दैट इज ऑल्सो नॉट पेटेंटेबल। सो इफ यू सी सेक्शन 3E, इट सेज मेयर एडमिक्सचर लीडिंग टू एग्रीगेशन ऑफ प्रॉपर्टीज इज ऑल्सो नॉट पेटेंटेबल। अगर हम दो चीजों को मिक्स कर लें और वो दोनों चीजें मिक्स होके एक एग्रीगेशन ही देती हैं उन दोनों की प्रॉपर्टीज का कॉम्बिनेशन है वो, बियॉन्ड एनी अनएक्सपेक्टेड रिजल्ट्स, तो वो भी पेटेंटेबल नहीं होता है। Likewise, if we see section 3F, mere aggregation or application of devices in the known way is also not patentable. अगर हम कोई कुर्सी और चेयर दोनों को, कुर्सी और टेबल दोनों के फीचर्स दोनों को कंबाइन कर देते हैं तो दैट इज ऑल्सो नॉट पेटेंटेबल बिकॉज दोनों के जो फीचर्स हैं दैट आर नोन, ओके, और उनको जो मर्ज करना इज नॉट आई मीन इंटेलेक्चुअल स्किल दैट इज एक्सपेक्टेड। सो लाइकवाइज अकॉर्डिंगली दैट इन्वेंशन इज नॉट पेटेंटेबल। लाइकवाइज अगर हम कोई मेथड डेवलप करते हैं एग्रीकल्चर या फिर हॉर्टिकल्चर का, वो भी पेटेंटेबल नहीं है। अगर हम कोई मशरूम ग्रो करने की कोई टेक्निक है, ओके, उसको हम पेटेंट कराना चाहें तो वो भी पेटेंटेबल नहीं है अंडर सेक्शन 3। लाइकवाइज सर्जिकल, क्यूरेटिव, प्रोफाइलाइटिक और डायग्नोस्टिक और थेरेप्यूटिक प्रोसेस फॉर ट्रीटमेंट ऑफ ह्यूमन एनिमल्स इज ऑल्सो नॉट पेटेंटेबल। अगर हम किसी के उपचार को लेके या रोग के निदान को लेके कोई हम लोग प्रोसेस डेवलप करते हैं तो दैट इज ऑल्सो नॉट पेटेंटेबल। इसी तरह से अगर हम सेक्शन 3J देखते हैं तो प्लांट्स और एनिमल्स इन होल और एनी पार्ट अदर देन माइक्रोऑर्गेनिजम्स आर नॉट पेटेंटेबल। तो प्लांट्स और एनिमल्स को अगर और एनिमल्स की हम बात करते हैं या फिर उनके किसी अंग की बात करते हैं, वो भी पेटेंटेबल नहीं है। इसमें हालांकि कुछ एक्सेप्शंस है माइक्रो ऑर्गेनिजम्स के लिए, अगर ह्यूमन इंटरवेंशन है तो माइक्रो ऑर्गेनिजम्स को अलाउ किया जाता है। इफ यू सी सेक्शन 3K, मैथमेटिकल एंड बिजनेस मॉडल्स, दे आर ऑल्सो नॉट पेटेंटेबल। Likewise in section 3L, if you see cooperatable subject matters जो हैं वो भी पेटेंटेबल नहीं होते। स्कीम या फिर मेथड मेंटल एक्ट के या गेम प्ले करने के, वो भी पेटेंटेबल नहीं है। प्रेजेंटेशन ऑफ इंफॉर्मेशन इज नॉट पेटेंटेबल, जैसे हम लोग ये प्रेजेंटेशन दे रहे हैं तो दैट इज ऑल्सो नॉट पेटेंटेबल अंडर सेक्शन 3। इसी तरह से इंटीग्रेटेड सर्किट जो हैं वो भी पेटेंटेबल नहीं है बिकॉज वी हैव अ सेपरेट लॉ ऑन दीज इंटीग्रेटेड सर्किट्स, तो इनको हम वहाँ रजिस्टर कर सकते हैं। दैट्स द रीजन उसको यहाँ से हमने हटाया है। Law doesn't allow to patent integrated circuits. And most importantly, अगर हम section 3P देखते हैं तो traditional knowledge based जो inventions हैं, which in effect are traditional knowledge or aggregation of their known properties, those are also not patentable. तो ये सारी conditions हैं जिनमें हालांकि invention है वो, but still they are not patentable. और most importantly, section 4 कहता है कि अगर atomic energy related invention है तो वो भी patentable नहीं है इंडिया में। ठीक है, तो ये सारी बात थी कि क्या चीजें पेटेंटेबल हैं। वी टॉक्ड अबाउट द पेटेंटेबल सब्जेक्ट मैटर। अगर हम उस पेटेंट फाइलिंग की बात करते हैं, सो दिस इज द प्रोसेस विच हैज बीन आउटलाइंड। प्रोसेस है ये पेटेंट फाइलिंग का, और जो पेटेंट रेगुलेटरी बॉडी है वो कंट्रोल CGPDTM, ऑफिस ऑफ CGPDTM है, विच हैज 4 ऑफिसेज अक्रॉस इंडिया। सो वी हैव इन दिल्ली, कलकत्ता, मुंबई एंड चेन्नई। तो जिस भी जुरिडिक्शन में आप फॉल करते हैं, जो आपका ऑफिस है वहाँ जाके और या फिर ऑनलाइन आप फाइल कर सकते हैं। सो यू कैन फाइल अ पेटेंट एप्लीकेशन। अगर आप, देयर आर 2 ways ऑफ फाइलिंग इट। वन इज लाइक यू कैन फाइल प्रोविजनल एप्लीकेशन एंड वन इज लाइक यू फाइल द कंप्लीट इन वन गो। अगर आप प्रोविजनल फाइल करते हैं तो यू हैव 1 year टू फाइल अ कंप्लीट एप्लीकेशन। जिन सिनेरियोज में आपके पास स्टिल इंप्रूवमेंट करने का टाइम होता है इन्वेंशंस में, तो आप उसमें प्रोविजनली फाइल कर लेते हैं, वेर इन यू गेट 12 months टू कंप्लीट योर इन्वेंशन एंड यू कैन फाइल द कंप्लीट invention, the specifications of the patent application within 12 months from the date of provisional filing. जब हम पेटेंट फाइल कर देते हैं तो नॉर्मली वो पेटेंट एप्लीकेशन कॉन्फिडेंशियल रहती है और 18 months में पब्लिश होती है. ओके, इट्स अ नॉर्मल प्रोसेस. मगर आप अर्ली पब्लिकेशन अगर आप कराना चाहते हैं तो यू कैन फाइल अ रिक्वेस्ट फॉर अर्ली पब्लिकेशन, जिसमें वो नेक्स्ट मंथ पब्लिश हो जाती है. टू रिड्यूस द ड्यूरेशन ऑफ ग्रांट लोग इसको यूज करते हैं. अगर आप जब पब्लिकेशन की रिक्वेस्ट डाल देते हैं वो पब्लिश हो जाती है इन द नेक्स्ट मंथ और आफ्टर 18 months, फिर आप जो है आप यू हैव टू फाइल अ रिक्वेस्ट फॉर एग्जामिनेशन. तो इसमें अगर आपने रिक्वेस्ट फॉर एग्जामिनेशन फाइल नहीं की तो आपकी एप्लीकेशन एग्जामिनेशन नहीं होगी. ओके, सो इट्स अ मस्ट. तो दैट एक्शन कैन बी टेकन विद इन 48 months और आप उसको एट द टाइम ऑफ फाइलिंग कभी भी कर सकते हैं. ओके, तो वंस यू हैव फाइल्ड द रिक्वेस्ट फॉर एग्जामिनेशन, इट इज एग्जामिन्ड. ओके, एंड it is examined and the reports are generated. Okay, तो first एग्जामिनेशन रिपोर्ट आती है जिसमें जो भी ऑब्जेक्शंस होती हैं पेटेंट ऑफिस की वो आपको कम्युनिकेट की जाती हैं. यू हैव टू कंप्लाई एंड नो फुलफिल दोज रिक्वायरमेंट्स विच हैव बीन मेंशन्ड इन द एग्जामिनेशन रिपोर्ट विद इन 12 months. अगर आप सारी चीज़ें फुलफिल करते हैं और द इन्वेंशन इज प्रोसेस्ड एंड आई मीन इज फुलफिलिंग ऑल द कंडीशंस प्रेस्क्राइब्ड, द पेटेंट इज ग्रांटेड. ओके, तो पेटेंट ग्रांट होने के बाद में यू कैन रिन्यू इट till you are interested in that invention. There may be a scenario wherein the patent is denied. Okay, so उसमें फिर appellate proceedings होती हैं. You can challenge those orders of denial. और इसमें आप अगर grant हो गया है तो you can go for post grant opposition also. In case somebody interested can go for post grant opposition. Likewise, अगर अब कोई third party है जिसको कुछ which has who feels के जो grant है that is not in order और जो invention है that is not falling within the boundaries of the law, then they can go for pre-grant opposition before the grant of patent also. So this is the process जो है. इसमें कुछ variations होती हैं जो अभी टाइम नहीं है तो नहीं बता पाएंगे हम लोग, but this is the broad overview. ठीक है. Likewise, अगर आपका पेटेंट ग्रांट हो गया है, now you have a right to restrain others. Okay, with regard to the use of the technology or the product or the process which has been patented. तो अगर कोई आपके बिना ऑथराइजेशन के आपके ग्रांटेड पेटेंट्स को या तो बनाता है या उसको सेल करता है या ऑफर करता है सेल करने के लिए, या फिर वो प्रोडक्ट को इंपोर्ट करता है, ठीक है, इन इंडिया जहां आपका पेटेंट ग्रांटेड है, तो दैट पर्सन इज इन्फ्रिंजिंग ऑन योर राइट्स. लाइकवाइज अगर प्रोसेस की आप बात करते हैं तो कोई अगर उस प्रोसेस को यूज कर रहा है फॉर डेवलपिंग अ प्रोडक्ट आई मीन समथिंग, और वो उस प्रोसेस को सेल कर रहा है या उसने कर दिया है, तो लाइकवाइज अगर वो इस तरह की चीजें करता है विदाउट योर ऑथराइजेशन, देन देयर इज अ इन्फ्रिंजमेंट. और इन्फ्रिंजमेंट जो है ये काफी तरह की होती है. वंस यू फाइंड आउट कि इन्फ्रिंजमेंट हुआ है, सो यू कैन approach the respective, I mean the judicial forum to restrain the party, that infringing party to I mean stop the infringing activity. और जब हम infringement की बात करते हैं तो बेसिकली या तो डायरेक्ट इन्फ्रिंजमेंट होती है या इनडायरेक्ट. तो when we talk about direct infringement, that can be of literal or doctrine of equivalence. इसको हम ऐसे समझ सकते हैं कि दो प्रोडक्ट्स हैं. ओके, वन इज योर पेटेंटेड प्रोडक्ट और एक है जो इन्फ्रिंजिंग प्रोडक्ट है. इन केस द बोथ प्रोडक्ट्स हैव सिमिलर एलिमेंट्स without any, I mean you don't require any further investigation or I mean any other activity to find out, so that is literal infringement. Okay, this is the plain infringement wherein you can find out that both the products have same elements. मगर in case of doctrine of equivalence, उसमें क्या होता है कि जो एलिमेंट्स हैं दे आर आई मीन they are performing the substantial function, okay, in substantially same way to deliver same result. तो technically there is no literal infringement. However, जो आप वो फंक्शन जो कर रहा है प्रोडक्ट, इन्फ्रिंजिंग प्रोडक्ट, और जिस तरीके से वो कर रहा है और जो रिजल्ट वो जनरेट कर रहा है, दे आर इक्वली सब्सटेंशियली सिमिलर. तो इस केस में लिटरल नहीं है, बट ड्यू टू डॉक्ट्रिन ऑफ इक्विवेलेंस वी कैन से दैट देयर इज इन्फ्रिंजमेंट ऑफ द प्रोडक्ट. ओके, तो ये क्लेम कंस्ट्रक्शन से हम लोग जो है वी फाइंड आउट के डॉक्ट्रिन ऑफ इक्विवेलेंस के अंडर में इन्फ्रिंजमेंट है कि नहीं. ओके, when we talk about indirect infringement, then there can be induced or contributory. Induced में ये होता है कि some third party has induced the infringer to act on it, या फिर somebody has not done it but there is a contributory participation of that person. So in that case also, in case there is a corroborative effort of infringing your product, so you can make out कि आपका किस category में infringement है, and these categories are well recognized under law also, and you can get the relief under it. ये हमने patents की बात की थी. Now we'll discuss about something about copyrights. Okay, so these copyrights are the bundle of rights which are given to the authors. Okay, so the authors of the literary work, okay, and artistic work, they are given certain rights. In addition to it, the producers of musical recordings and the producers of cinematographic films, they are also given copyrights. Okay, so these are the bundle of rights wherein there are moral rights, there are economical rights, there are certain and I mean neighboring rights also. और जो मोटिव होता है कॉपीराइट का वो ये है कि जो लिटरल और आर्टिस्टिक क्रिएशंस हैं उनको हम लोग एनकरेज करें. ओके, और जो एफर्ट्स रहते हैं ऑथर्स के, ओके, आप सबने देखा होगा जब कोई नॉवल कोई लिखता है तो इट रिक्वायर्स अ लॉट ऑफ क्रिएटिविटी एंड आई मीन द एक्सपर्टीज. ओके, एंड इट्स अ एक्टिविटी विच इज टू बी प्रोटेक्टेड. तो कॉपीराइट में हम लोग इन चीज़ों के लिए प्रोटेक्शन देते हैं और जो उनके एफर्ट्स हैं उनको मॉनेटरी रिवार्ड मिले उसके लिए हम लोग ये लॉ जो है प्रोटेक्ट करता है. और दीज आर एक्सक्लूसिव राइट्स गिवन टू देम फॉर आई मीन अ वेरी लॉन्गर पीरियड. जो पेटेंट्स थे जो हमने भी डिस्कस किए थे वो दैट इज दोज आर फॉर 20 years. बट जब हम कॉपीराइट्स की बात करते हैं तो दे हैव आई मीन द पर्सनल टच, जिसमें आर्टिस्टिक और क्रिएटिविटी की बात करते हैं तो इट इज हैज अ लॉन्गर पीरियड एज कंपेयर टू पेटेंट्स, एंड दिस इज लाइक 60 years का इसका ड्यूरेशन होता है, विच स्टार्ट्स आफ्टर द डेथ ऑफ द ऑथर. और उनके डेथ के भी नेक्स्ट कैलेंडर ईयर के फर्स्ट डे से शुरू होता है. तो इट इज लाइक द लाइफ टाइम ऑफ द ऑथर प्लस 60 years starting from the next calendar year. Okay, or
Anil ji, can you hear me?
Yes.
There's a request to speak more in English, please, because we've got people from the south and all. So if you
okay,
can stick to more English, please. Thank you.
Sure. So when we talk about copyrights, I mean, if we talk about copyrightable subject matters, so there are, I mean, literary, dramatic and dramatical music and artistic works. Okay, so इसमें जो difference है, the difference that we have here is the literary, dramatic, musical and artistic work has to be original in nature. Okay, however, the degree of originality is not similar with regard to the sound recordings and cinematographic films. So you can understand this thing like is when we talk about a sound recording that may have a literary work also because there are lyrics. Okay, and it is a combination of lyrics plus musical work. Okay, so the requirement is the literary work, that is the lyrics must be original and musical work should be original. But when we combine these two items to arrive at a sound recording, that may or may not be original because we have combined two existing things. Okay, so the originality requirement is not present in sound recordings and cinematographic films. तो इसको आप ऐसे समझ सकते हैं कि ओरिजिनलिटी जो है वो जरूरी है. इट इज एसेंशियल इन विद रिगार्ड टू लिटरेरी वर्क्स. अगर हम व्हेन वी टॉक अबाउट पोएम्स, स्टोरीज, नॉवेल्स, रिपोर्ट्स, so they have to be, I mean, they are falling under literary work and they have to be original. Likewise, when we talk about plays, dumb shows and choreographic work, they falls under dramatic work. Then compositions, graphical notations of songs, and these things are falling under musical works. Likewise, if we talk about artistic works, it includes painting, sculpture, drawings and all those related items. Okay, so ये हम बात कर रहे थे copyrightable subject matters की. And the essential thing that is to be noted is the protection is given to the expression of idea, not the ideas. Okay, so in case there is a story, okay, we have seen Ramayana, so there are no certain essential ingredients. The story of Ramayana is almost same in all the plays or movies. However, the way it is expressed, it may be different. Okay, तो जो essential element है, idea जो है, that is not protected under copyright law, but the way it is expressed, जो dialogue delivery है, the costumes that we use, the plot that we are using, and the choreography that has been done in that program is copyrightable subject matter. Okay, so this is all about the copyrightable subject matter. And when we talk about the rights, and I mean the rights granted under copyright, so it gives a right for reproduction of works. Okay, so the author or the owner, the owner of the copyright may reproduce its work, okay, in printed publications or any other material. They can reproduce it in soft copy also. They have a right to distribute the copies of the work, and they have the right to make public performances also. Okay, so this right of copyright also includes broadcasting rights, which includes the communication of work to the public. It also includes the translation of work. Okay, these are known as the derivative works. Okay, and it also includes the adaptation also. When we prepare a movie out of novel, that it falls under adaptation. So changing the format of the copyrightable subject matter is an adaptation, and that is also protected. As I talked, there are certain rights. First is the economical right, जो आप जो है इसको लाइसेंस आउट कर सकते हैं. ओके, और आप जब अपने राइट्स को फॉलो अप एंजॉय करते हैं, तो यू गेट सर्टेन मॉनेटरी बेनिफिट्स. So it includes economical rights, it includes moral rights. The author has the moral right of no attribution. He can say this work belongs to me. He can restrain other parties from mutilating his work. Okay, or wrong attribution भी he can protect the wrong attribution of his work, और उसका destruction को भी वो रोक सकता है. These things fall under moral rights. Then the performers have a separate right of performance also. इसको ऐसे समझिए जैसे मूवीज में the owner of a cinematographic film is a producer. Okay, but in case the actor or the actress who have performed, या फिर किसी ने म्यूजिक गाना गाया है उस cinematographic film में, so the performance, they are also having separate rights. Okay, and those rights are different from the copyright which vest in the producer of the cinematographic film. So when you license in or license out these copyrightable subject matters, you have to ensure कि आपने वो rights भी performers से properly लिए हैं. Okay, तो जब हम infringement की बात करते हैं, तो unauthorized use of these copyrightable subject matters without the permission of the owner leads to the infringement of copyright. और जब copyright होता है, तो you have various relief under law. So under civil law, you have injunctions. आप उसको रोक सकते हैं, the other party who is infringing. You can ask for damages, you can ask for the accounts, the benefits that they have gained out of that infringement, and you can also ask for the cost. Okay. Sorry. So when we talk about criminal remedies under infringement, you can, these activities are cognizable. So you can approach police directly, and you can request the police to take action as per law, and there is a provision of imprisonment and fine also under the criminal provisions in this law. When we talk about administrative measures, so there are rules wherein you can request the custom authorities at the border to stop the entry of the infringing items. So there are rules wherein you can register an item, and whenever there is any item which is similar to the copyrightable subject matter that you have submitted, they will first ask whether those items should be allowed to be entered in the jurisdiction or not. Sorry. So these were, this was all about the copyrightable subject matters. Now we will talk about trademarks. So these trademarks are basically consumer-centric IP laws. So these are the signs or marks that a producer of product or the person who is delivering services uses to identify his product or services from others. Okay. So in a case when we use certain marks, like we have this mark of Mercedes-Benz. So we all identify this mark. Okay. So when we saw this mark, there is undisputed impression that the car that we are looking at is coming from Mercedes-Benz. Okay. And these marks, they have they have a goodwill attached to them. Okay. That's the reason they creates a huge amount of trust in the public. So these are the distinctive marks which identifies the source of the product or the service in the market. Okay. And that's the reason they are very precious. and all the companies, they invest, I mean, a huge amount of money with regard to protection and with regard to securing rights over it and protecting the misuse of their symbols. So when we talk about trademarks, these marks may contain words, they may contain designs, signs, symbol, shape of goods. They may contain the packaging labels also. It may contain color or combination of colors. Okay. And they may also, I mean, the only requirement that is prescribed is that mark should be capable of being represented graphically. And that's the reason some of the countries, they have registered the sound marks also. Okay. So there are graphical notations wherein we can graphically express the voice. And that's the reason those marks are being registered in certain jurisdictions. Likewise, if we talk about the smell, okay, तो स्मेल को भी हम लोग केमिकल फॉर्मूले से एक्सप्रेस कर सकते हैं, तो दैट्स द रीजन इवन स्मेल मार्क्स आर आल्सो रजिस्टर्ड. कुछ टेनिस बॉल्स को आई मीन दे हैव अ स्पेसिफिक स्मेल ऑफ दिस प्लूमेरिया फ्लावर. ओके, तो चंपा की खुशबू आती थी उन टेनिस बॉल्स से. सो those smell marks were registered for those, I mean, by the producer as a trademark in that case. Okay. तो जब हम बात करते हैं ट्रेडमार्क्स की, तो सर्टेन कैटेगरीज हैं जो हमने ऑलरेडी डिस्कस कर ली हैं. व्हेन वी टॉक अबाउट द टर्म ऑफ प्रोटेक्शन, द टर्म ऑफ प्रोटेक्शन फॉर ट्रेडमार्क्स इज नॉर्मली 10 years, which can be further renewed for 10 years, and it can be renewed till you are using it. Okay, so it's a very long, I mean, period of protection granted. So you can renew it for, I mean, end number of years till you are using it. You have to just pay the renewal fee every 10 years. Okay. And the best part is, I mean, like patents, like copyrights, these trademarks are also licensable. Okay, in case you are not using it yourself, you can license it to others, partially or completely. Okay, so in case you have a trademark which has established goodwill in the market, you can license it to others. आप उसको एक स्टेट के लिए किसी को दीजिए, दूसरे स्टेट के लिए किसी और को दीजिए. So you can do it partially. आप jurisdiction wise भी उसको जो है दे सकते हैं, या फिर you can give it to a single party for whole country. Okay, so this is one of the example of trademarks. Although this example is from Kenya, but this is the best example. Okay, one of the best examples wherein the tribal people, they have used the law of trademarks in Kenya for their benefit. Okay, so this is टाइटा बास्केट्स. ये जो है, ये ट्रेडिशनली जो है डेवलप की जाती है कीनिया में, and these are cultivated, I mean, these are prepared from a sisal plant which is cultivated there. Okay, so इसकी जो weaving technique है, that is also traditional. Okay, और इसके जो fibers हैं वो भी traditionally develop किए जाते हैं. और best part है कि although it can be registered under GI, but since their law was not so much supportive in terms of GI, so they registered it as a collective mark. Okay, which has a specific quality standards. So Taita Basket Association ने register किया इसको under their own law in Kenya, which is the best example wherein the traditional knowledge was trademarked and was used by the tribal people for their benefit. Okay, and it has become a very very I mean good product of that country. Okay, so ये trademark के बाद में now we'll discuss about the designs. So when we talk about designs, so basically जो designs होते हैं, these are the features of shape or configuration. Okay, तो जैसे like we see these bottles in the right, they have different physical structure. Okay, so they have different shapes and configurations. So the visual effect that we can see in these shapes and configurations are protected under Designs Act. Okay, so these surface patterns are also protected. Okay, it may also include patterns and ornamentation. Okay, तो एक तो आपका फिजिकल फीचर हो गया, the things that we can see through our eyes. दूसरा है the kind of patterns that we use. Okay, तो ये जो आप, if you can see the design on this shoe, that is a pattern which is, I mean, applied to this article. Okay, so that is also protected under design. Likewise, जैसे हम लोगों के compositions होते हैं लाइंस के या फिर कलर्स के. ओके, सो लाइक वी सी, आई मीन देयर आर 3 लाइंस इन एडिडास. ओके, सो दोज 3 लाइंस ऑफ एडिडास, they are protected under trademark law as their trademark and also under design law. Okay, the only drawback that we have in designs is कि इसका जो duration है that is smaller as compared to trademarks. Okay, but in case you have a new or innovative design, I mean that you have created, you can decide whether you should go for, I mean, the both laws, or you can decide a single law which is more, I mean, beneficial for the product. Okay, the only condition is कि ये सारे physical features के अलावा that feature has to be applied on the article. Okay, और article के apply, जो article में जो when you will apply that feature to that article, that has to be done either manually, mechanical, or by a chemical process. So that has to be done by an industrial process. Okay, and the limitation that is there is like the visual part is only protected. Okay, if you have a very unique design of a watch, wherein, I mean, the watch is uniquely designed, it has a physical surface pattern which is unique. Additionally, it has certain internal elements also which are visible through the glass, and those patterns are, some of them are not visible also. So the condition is like whichever is visible to you is protected, and something which is not visible is not protected under design law. Okay, so these are the conditions. And when we talk about originality, the only requirement under designs is that the pattern is there, the subject matter should be original in nature. Okay, और जो originality का standard है बहुत strict नहीं है. If you see the standard of originality that is being applied in designs is like कि ये जो design shoe में है, if this design is applied to some other article, okay, like if I apply this article to a car, okay, then this design will be original with respect to car. Okay, so once you will apply it to shoe, it is original for that. Okay, but in case you apply it on a car, it will become original for that car also. Okay, because if you see the motifs that are being put in there, I mean, they require a certain kind of intellectual effort. Okay, जब कार में आप इसको लगाएंगे तो you have to know design कि आपको किस एंगल से किस फ्लावर को कहाँ प्लेस करना है. Okay, so it requires a certain degree of creativity. That's the reason the criteria of originality is less strict in designs. If you talk about the subject matter, if you talk about what is not registered under designs, then the inner portion of the article which is not visible is, I mean, not registrable. We discussed already. Then buildings and structures, they are, I mean, prohibited from being registered in designs. Then the part of an article which is not sold separately. Okay, the condition is, I mean, the item which is sold separately, okay, as a single element, I mean, single item is given the protection. Okay, in case, I mean, there are two elements which can't be sold separately, तो उनको अलग-अलग नहीं मिलेगा protection. They have to be applied as a single item. Okay, then under law, the variation which is very common in trade, वो भी protection नहीं मिलता है. Then stamps, labels, tokens, medals, there are certain category of items which are disclosed there, वो भी उनको protection नहीं मिलता है. Mere change in size also not protected under designs. Okay, तो किसी बड़ी कार का miniature model is not protected. Okay, because they both are same. The only difference is in the ratio. Likewise, emblems, flags of nations, computer chips, integrated circuits, इनको भी protection नहीं मिलती है. When we talk about the duration of protection, it is for 10 years, which can be further extended for 5 years. Okay, the complete tenure of protection is 15 years. अभी हम लोग फिर GI की बात करेंगे. These GIs, these geographical indications, okay, these are the indications which identify certain goods, okay, which is linked to a specific jurisdiction. Okay, like we see this Darjeeling tea. Okay, so we all know that Darjeeling tea is produced or it is cultivated in a specific region in Darjeeling. Okay, so the Darjeeling tea has a specific reputation which is linked to the geographical location in that I mean region of Darjeeling. Okay, so there is a reputation, there is a product which has a reputation, the established reputation, which is linked to the environmental factors, okay, of a geographical location. Then we can register this Darjeeling tea either as a word or as a logo for as a GI under the GI Act. Okay, so once it is registered, then the applicant, okay, and the best part is this is a collective right. Okay, तो इसमें जो एप्लीकेंट होते हैं दे आर बेसिकली द एसोसिएशंस विच आर वर्किंग फॉर द बेनिफिट ऑफ दोज द पीपल हु आर कल्टिवेटिंग दोज प्रोडक्ट्स, या फिर जो मैन्युफैक्चर करते हैं. तो लाइकवाइज इफ यू टॉक अबाउट दार्जिलिंग टी, द एसोसिएशन देयर दैट इज द एप्लीकेंट. ओके. और जो ग्रो करते हैं उस प्रोडक्ट को, दे आर द यूजर्स. ओके. So there are two registers. One is for the applicant and one is for the users. Okay. So in all almost all scenarios, जो applicant होते हैं वो associations होती हैं, और जो users होते हैं वो individual लोग होते हैं. Okay. So it's a collective right. और जो हम बात करते हैं, I mean these products may include agricultural products, they may include foodstuffs. They also include wines, spirits, and other handicraft items. If you want to see the list of these GIs, that is also available in the website given here. Okay. जैसा कि हमने बात किया, if you talk about the key attributes, तो पहली जो attribute है that is geographical area. Okay. तो कोई अगर product है that originates naturally, तो उस product को उस area में ही originate करना पड़ेगा. Okay. In case it is originated beyond that jurisdiction which has been outlined in the application, तो protection नहीं मिलेगा. अगर हम process goods की बात करते हैं तो at least one stage of preparation, okay, has to be undertaken in that geographical area. और उस product की एक distinctive reputation होनी चाहिए. Okay. With regard to the nature of goods, the quality, okay, there must be a domestic or global reputation of that product. Okay. और वो जो reputation है, that has to be linked to the geographical area directly. Okay. So that if we talk about the given quality, that quality must be linked to the geographical area directly. Okay. In case there is no linkage, then the protection cannot be given. Okay. अगर हम किसी process good की बात करते हैं तो the skills that have been generated over the time in that area, या फिर कोई जो key ingredients we are using, the raw material that we are using must be from that location. Okay. So these are certain criteria जिसमें आपको those have to be fulfilled, and this whole criteria should give out a uniqueness to that product. Okay. So these are the basic key attributes which are required. Apart from that, आपको फिर वो details देनी है. The applicant has to be an association that is working for the interest of producers, और आपको दूसरे fulfillments पूरी करनी होती है. Okay. We already discussed that the products registered under GI Act are agricultural, natural, or manufactured. और manufactured जो है, they can further be handicrafts, manufactured industrial goods, or foodstuffs. These are some of the examples wherein you see, these are some of the examples which have been registered in India. Okay. However, some of the applications like Apatani textile is pending before the GI registry. So this is one of the sweetest battle that happened. So both the Banglar Rasgulla and Odisha Rasgulla were the applications were filed for registration of GIs. So it was a disputed matter wherein both the states, West Bengal and Odisha, they claimed rights over the Rasgulla. Okay. However, after examination the application, the registry found that these two items are completely different. They have different taste, they have different texture. Okay. And in fact the process of preparing both of the products are different. Therefore these both applications were allowed with the condition that they must apply separately, and both the applications were granted rights. Okay. So today Banglar Rasgulla and Odisha Rasgulla both are registered under GI. This is one of the this is another example with regard to GIs. This worldly paintings, they are being practiced in Maharashtra. Okay. So this is a traditional item which is traditional item giving protection under GIs. So if the people who are from that area, they must be knowing that these are the paintings which are put on the walls during certain occasions in that region. Okay. And the best part is they use a special type of paste prepared from rice, water, and gum. Okay. And the sticks that are used as paintbrush are also prepared traditionally. Okay. So the protection has been given under class 16, 20, and 25. Although these paintings are practiced on wall, but you see the protection has been given under class 16 for to apply these paintings on paper, notebook, cardboards. Likewise, it is also registered under class 20. Okay, it is for it is for the products which fall under this wood. They includes furniture also, and likewise it is given protection under class 25 for canvas, cloth, and garments. Okay, so traditionally it was practiced on wall, but the protection has been given for 3 different classes. Okay, wherein these paintings can be applied. Okay, so this is how GIs can be further improvised and used for the benefit of the local artisans or the people who are using it. The another IP rights that we will discuss is the plant variety protection. Okay, so for new varieties of plants, the protection has there is a law under which the protection is being granted. Okay, and the 4 type of rights. These are the 4 type of varieties that can be registered under Indian law. So one is new variety, and if we talk about new variety, in case variety which has been developed and confirms these 3 essential criteria of novelty, distinctiveness, uniformity, and stability, they are given these specific rights. Okay, the breeder gets the right to produce, sell, market, and distribute along with import and export of the variety. Okay, the duration is also distributed. In case it's a tree, then it is initially for 9 years, which can be extended to 18 years. And for other plants, it is for initially it is granted for 6 years, which can be extended for further for a total of 15 years. Likewise, when we talk about extant varieties, the unique feature is novelty is not required in extant varieties. Okay, so these are the varieties which are notified under Section 5 of Seeds Act. So government notifies certain varieties under Seed Acts, so they can be registered as extant varieties. Okay, so the rights are almost similar with some deviations, and the protection given is 15 years from the date of notification by the government. Likewise, when we talk about farmers variety, okay, so these are the 3 essential ingredients. However, the novelty is not required in farmers variety. Okay, so these are the farmers varieties are the varieties which have been traditionally cultivated or evolved by the farmers. Okay, or they may include the wild relatives or land races of a earlier practiced varieties by the farmers. Okay, in those scenario also the rights are given to the farmers. Okay, in new variety and extant variety it is for breeders, but in farmers variety the right has been given to the farmer. Okay, and the duration is almost same. The fourth kind of variety that is registered is essentially derived varieties. Okay, so these are the varieties which are derived from earlier a variety which is practiced earlier. Okay, so the only condition in this variety is like since it is based on an earlier existing variety, so the right the permission or the authorization from the owner of that variety is also required. Okay, so this is something which is it's a kind of derivative work wherein the improvement has been done on a earlier existing variety. Like this variety also the rights are given to breeder for limited time. So for trees it is 9 years, which can be extended up to 18 years, and for other species it is 6 years, which can be further renewed to 15 years. So apart from these, the plant varieties, we have this special kind of law which is giving protection to semi-conductor integrated circuits and layout designs. Okay, so when we see these miniature electronic equipments, we see these the kind of these mesh the mesh work. Okay, so there is a motherboard kind of thing wherein some chips and microchips are embedded on the board. So when we see the configurations of these elementary circuits and these items is disclosed by way of a layout design. Okay, that is known as mesh work. Okay, so under this law you can register these layout designs. Okay, so the protection is granted to the layout design. Okay, for the integrated circuits. Okay, and making a thing, making a instrument, electronic instruments smaller requires a huge amount of creativity and investment. Unfortunately, this law is not used as it was perceived, but still this is very important. And this is the layout design. If you can see I mean, the layout design, there are certain symbols by which we express it. And these layout designs, okay, they can be registered, okay, under the law. And when we talk about the requirement of, the fulfilling the requirements for registration, it must be inherently distinctive, okay. And there is a requirement of originality, okay. And the condition is like, in case the integrated circuit was exploited earlier than 2 years, then that layout will not be considered for registration, okay. So you have a window of 2 years. So once you make commercial use of a layout designs, in case you want to secure it, you have a period of 2 years for for applying for the protection. However, the conditions that are required for getting the layout design registered is, it must be inherently distinctive, it must be original with regard to the application, okay. And combining two layouts may lead to an original item here, okay. So the standard of originality is not so strict as we have in patents, okay. But the combination should be in a manner that it must include some kind of intellectual creativity in that. And when we talk about the duration, it is, the duration for the protection is 10 years, okay. And it is counted from the date of filing of application or the date of the first exploitation. That can be 2 years before the date of application, okay. So now if we see, we would be able to understand that IP has certain elements, okay. So this, if you see this, the Coca-Cola, these Coca-Cola bottles, you can know that there are the text Coca-Cola or the logo that they are using is trademark, okay. Then they have certain technological interventions therein, like the lid which has been placed above this can. It is patentable subject matter. Then the label that we are using on the bottle is copyrightable subject matter. Then we have a design, a unique design given to that bottle, which can be registered under Designs Act. Again, this bottle opener is a technological output that can be patented, and the formula that we use is a trade secret, okay. So trade secret is like, you doesn't want to disclose something, okay, and you want to keep it a secret. So it's basically, there is no law on it, but the Contract Act in India is basically governing it. So in that scenario, you have to have an agreement with your employers to state and agree that you will not disclose these, the formulation or the item which is being protected there, okay. But in case it is violated or disclosed, then you have limited protection. So you have to proceed ahead under the Contract Act for getting the compensation, or getting the relief from that person, okay. So now we can now make out that in fact all the IP related tools, they are almost they almost have some similarities, although they differ in some matters also, okay. So when we talk about the protectable subject matters, then they basically covers either product or a process having some creative activity. So then there is a criteria of protection, okay, which is unique or having with some similarities, okay. And all these laws, they confer exclusive rights, okay, which can be further monetized. You can license them, okay. And there are certain limitations and exceptions with regard to the domestic requirement. So in case the country has some specific requirements, like India doesn't allow patents on agriculture, okay, these horticulture and agricultural practices. So that is our internal requirement. So that's we have imposed a limitation in that line. So all the countries, they have certain limitations and exceptions to it, okay. And all these IP, they have they are bound by time, okay. So that protection is not for eternity, but they have a time bound. They are giving for a time bound manner. When we talk about different differentiations with regard to these IP matters, then with these law, they cover different subject matters, okay. The requirement of grant are different, they have different conditions for protection, okay. And nature of rights are also different for all. I mean, they give different kind of rights under each law. Okay, so to summarize, now we can efficiently summarize that. I mean, and identify the different kind of IP rights. We have copyrights, which covers literary, musical, and artistic works. We have patents that covers inventions, trademark, certification marks, and collective marks. They are for trademarks. GIs are for the GIs are the signs, okay, that are specifically given to products having some reputation linked to the geographical origin, or I mean the place of manufacture. Then we have industrial designs. These covers the aesthetic element of products which are exclusively can be looked or feel. Then we have layout of integrated circuits and layout designs act, which covers the layout designs, and we have plant varieties. Okay, so to summarize, I mean, IPR tools are very effective in protecting and monetizing your rights. Okay, they protect the creativity and inventions. Okay, and if we talk about patents, designs, copyrights, they enable the creators and innovators to recognize. They give the recognition and commercial reward to the creators. And if we talk about trademark and GIs, they are basically consumer centric products. Okay, and they help to differentiate particular goods or goods. When you talk about trademarks, it includes both goods and services, and GIs for products only. Okay, then in case you have creative ideas or concepts, so these laws, they help us to convert your ideas and your intellectual efforts into assets, and they protect and boost innovation. Okay, and with regard to the businesses, definitely they give an edge over the competitors, and they just lead to the growth in your businesses. And basically, these IP also includes branding, and they also make you financially stable. So to summarize, these are the essential elements wherein the innovators can monetize, and they can get reap benefits out of their intellectual creations. This was all about the presentation, and now we can have some questions in case the attendees wish to ask something. Thank you.
Namaste, and thank you very much. Can you hear me? Anilji, can you hear me?
Yes, I can hear you.
Thank you very much. I think there was a lot of appreciation about what you have shared with them, and I'm sure that they will not just find this helpful in the context of IKS, but I think no matter what area of research they are doing, they will find this information very useful, so that they can accordingly orient their research in a more meaningful manner for themselves. So I now invite the participants to please ask your questions. Anilji will answer them. It is now about 5 o'clock, 5:03. We'll stop at 5:30. So we hope your questions will flow. And this is your opportunity to get Anilji. It's not so easy to get him. But they are very available. So if you ever write to them, then they always respond to questions and all. So please feel free to ask any questions you may have. Okay. So we have Apurva Srivastavaji who's asking, what is fanciful or arbitrary trademark?
See, if you talk about fanciful and arbitrary, okay. See, when we talk about trademarks, there are certain category of trademarks. One is like arbitrary is like you are using the word Apple for an electronic device. So it's completely different. There is no link. Okay. So this is arbitrary in nature and expression also. But when we talk about fanciful, so basically it may include some elements which make it different in terms of expression. Okay. So when we talk about trademarks, as I already discussed, they must be distinct. Okay. So distinctiveness is an essential feature for getting the trademark registered. Okay. And that distinctiveness, or in other words, the capability of differentiating it from others, should be inherent or derived. Okay. So when we talk about arbitrary marks, they are inherently distinctive. Okay. So when we say, we identify a electronic device by saying Apple, it is inherently distinctive. Okay, so there is no requirement of further discussion or elaboration to arrive to identify whether it is distinct or not. This is arbitrary, but for fanciful words, they may include some elements which may make it inherently distinctive, or they may get a distinctive character by continued use. Okay, so if we talk about the legal parameters, arbitrary marks are registrable per se. Okay, because they have inherent characteristic of distinctiveness. However, fanciful marks, they require an element of examination. Okay, so they may include something which is generic in nature and that is not protected under law. Okay, so when we say aaj tak, okay, so aaj and tak, these two words are completely used, okay, in the common language. But when we say aaj tak, it gives a secondary meaning. Okay, that secondary meaning is like we are talking about a news channel. So that the moment that distinctive character or secondary meaning starts, okay, that word requires registration under law. So this is how we identify these arbitrary and fanciful words. Okay, so basically it is a kind of a legal expectation from the marks for getting registration. I hope I answered your question.
Thank you, Anilji. Would you also like to stop the sharing? Then that way, we can see you on the full screen.
I have stopped sharing. I think this thing is being shared by. Yes.
Just 1 second. TKG. I'll just ask the question in the meanwhile. There's a question by Ritu Bajaj who's saying that can the same initials for a brand be registered? Like M is for McDonald, M is for some other, like small m is for McDonald, a big M for some other brand, for example. Is that possible?
See, I told you, for being a mark, for a mark to be registered, it has, first thing is it can be expressed graphically. So be it a small m or a bigger m, both can be expressed graphically. So both are registrable. However, the essential ingredient that is required after that is it has to be different from others. It must not be confusingly similar. Okay, so when we say small m, bigger m, then it creates a confusion in the mind of the consumer. So in case there is an iota of confusion in the mind of consumer, or it has an ability to confuse the consumers, then it is not registrable. So when you are going for a registration of a similar mark, you have to prove by way of a continued or use that there will be no confusion with regard to the the identification of the marks by the consumers. In case there is a confusion, then the registration will not be granted. This is the these are the parameters which are looked upon while granting the rights over trademarks.
Just 1 second. Thank you for that. There was another one here. There's Gopika RG who's saying, I have a doubt regarding the trademark for designs of products. Almost all products have the common design, which is its basic feature. Will such characteristic designs also be trademarked?
See, design is something different. Okay. As I told you, these designs, they are the features of shape or configuration. Okay. They may include ornamentation also and some lines or the combination of colors also. Okay. But you have to just see whether, under which category or product falls. However, being a student of law, you must understand that the duration under, the protection given under trademark law is very long. Okay. You can have that mark registered or on the the register of trademarks till you use it. You have to just renew it after every 10 years. Okay. But when you talk about registering an element which is also capable of being registered under trademarks, then you will have a limited protection. Okay. And the extent of protection given under Designs Act is 10 years, which can be extended further for 5 years. So no one who intends to have a brand, okay, be used for longer time will protect it for 15 years. Okay, so some of the elements like configuration of lines or patterns, they can be protected in the designs also and as a trademark also. But you have to decide under which law you have to protect it. Okay, my advice is always go for trademarks because you can continue to use it till you have an interest in it. Okay, but in designs you will have a limited period which will not be so beneficial. Okay, this is all about the confusion with regard to fall under subject matter falling under designs and trademarks.
Anilji, there's also a lot of, like I said, a lot of words of appreciation and gratitude for this important session. We have Dr. Madhumita Mondolji who's saying, if I want to file a patent on a process, what will be the total cost for that?
See, when we talk about cost, so I can just tell you the government fee. Okay, so there are two elements. One is attorney's fee that varies hugely in the market. One is government fee. Okay, so in case you want to file a patent application in your personal name, then it is very less. I think it's 1650 rupees. Okay, in case you want to file it in the name of a company, then it is 8,000 in case you want to file it online. Okay, and these are the two categories. However, in case you fall under startup category, it is reduced to, again, it has a rebate in case you are a MSME or a startup. So for attorney's fee, you can consult any of the attorneys which are available. Thank you.
Thank you. There's Dr. Anita Virginji who's saying, can you please give some possible ways for literature people to file patents?
Literature.
But I just ask you one thing here. For example, I'll just add to that. So for IKS, we've got so many shastras, in different languages, not just Sanskrit, but we've got so many of these literary traditions. Like, for example, let's say Kalidasa. We have filed a patent for Abhijnana Shakuntalam. Is that something that is fileable for a patent? This is my question, but Dr. Anita, if you want to unmute and specify yours, please feel free to let us know. If you want to raise your hand, we'll do that. But Anilji, in the meanwhile.
Before that, I must make it clear that literary elements, they are copyrightable subject matters. Okay, so for getting a patent, there must be a technology. Okay, so some technological intervention is being required. May it be a product, okay, or may it be a process. So for literary things, we must seek protection under copyright law. Until or unless there is no technological intervention, then we will not get the patent over, the item. So if you talk about the expression of the language, or if you talk about the stories, if you talk about the creative literary works, then we must seek protection under copyright law. So if you see section 3, it clearly says I discussed also copyrightable subject matters, they are not patentable. Okay, so it's a bar for getting patent over literary items.
Thank you. We've got Dr. Vemuriji who wants to ask a question. I'm unmuting you if you want to just ask. Dr. Vemuriji, please ask your question.
Hello, sir. Good evening. Thank you very much for this discussion. Of course, you have already answered some part of that question previously in the last, 2 minutes back. Actually, I'm just looking for a kind of, contemporary issues. If I can start interpreting using the Sanskrit grammar, like we have a lot of background knowledge on that, like Panini's grammar is one major thing. And they have already classified also on different ways. Of course, I can discuss exactly my specific problem, but I'm just looking for a kind of an idea how to really bring this grammar based upon the Sanskrit grammar. How can I make it a copyright of course, I asked for patent, but I'm not asking for patent. I understand technology is required for a patent, but a copyright in case linguistic point of view, if I just make it. So the interpretation based upon our ancient Sanskrit grammar, if I start interpreting the contemporary issues, can I apply for a copyright kind of a scenario? Is it logical or is it a vague idea? I do not know how to make it. Like you know, we have like a pramana. We have a pramana concept, like 6 pramanas are there, anumana or something like that. So based upon that, can I just make it a kind of a research methodology and start interpreting based upon the ancient knowledge? That's my simple understanding. We have a qualitative research methods, we have a quantitative research methods. And quantitative research methods with the statistics point of view, largely. But I'm just looking for the research methodology of the ancient technique and apply it to the contemporary issues, and whether I can build a copyright on that. If you want, I can send a mail later also, but I just for this particular discussion. Thank you, sir.
Yes. When we talk about interpretation of some language, so we must understand that something, I mean, there are certain elements of expression.
Anil, your voice has gone very soft for some reason.
Okay. Is it fine now?
A little louder, yes, please.
Okay. So when we talk about copyrightable subject matters, so first thing is the expression is very important. Okay. So the protection is given to the expression. If you develop a methodology and you are not expressing something which is unique, okay, you will not get protection. Okay. And methodology itself is not protected. Okay. There is something which is public juris. So we must understand that something is essential for performing an activity. Okay. So while interpreting Sanskrit grammar, there are certain concepts and principles which you have to follow. So as per law, those concepts and methodologies cannot be given. I mean, the rights over those things cannot be granted to a single individual. Okay. Being a public juris, other people, they have equal rights to use those things. Okay. But in case those rights are given to a single individual, he can restrain others from using those. So that's the reason you have to make a differentiation between this spirit and the expression. Okay. So in case your interpretation or the output that you are expecting is something which has an element of differentiation. Okay. So if I interpret that grammar, I will deliver something else. And if you interpret that grammar, you will deliver something, a different result. Then there are two different expressions that can be protected. However, in case the output is almost similar and it is essential for making that concept functional, then protection will not be granted. Okay. That is the reason I told you Ramayana, the story is same everywhere. But the way the people, they have delivered the product is different, and it has been protected under copyright law. I hope I have answered your question. Okay. So this concept you have to follow. Okay. And then in case you fulfill those criteria, then you will get the copyright over that. However, I mean, I don't think, I mean, the principles of interpretation, they are protected under copyright law. They must be open for all. Okay. In case you will get a protection for that, you will restrain others from using it. That is not expected out of these instruments of law. Thank you.
Thank you, Anil. There are quite a few questions. I don't know how we'll handle it, but I'll just go in the order that I have here. We've got 2 hands up, but I'll just take some questions on the chat before I continue. So, sir, if a design which has got patent in one country, maybe in India, whether it is possible to file patent in another country? If the patent was filed, so what is the procedure to recover or further procedure, sir?
See, each country has its own law. Okay. So in case you want to get a patent in India and a patent in US, you have to approach both the patent offices in India and US. Okay. Provided the date of priority plays an important role. Okay. So the novelty which we talked in patents, okay, has a global connotation. So in case you file a patent application in India today, so you can file a patent application in US by stating that you have filed an application in India on this date. So the novelty, the date of novelty will be the date of filing. Okay, so anything which existed before that date will be useful in identifying the novelty of your invention. In case you don't disclose, then your own invention which was previously filed in other jurisdiction will kill your novelty. Okay, so this is the rule. So you have to go to, you have to see the process in detail. Okay, in case you want to have patent in more than one jurisdiction. So some attorney can help you, to handle those issues. Yes, thank you.
Thank you. We've got Dr. Nigamma K, who's saying, can conceptual frameworks be patented? In the sense, in the context of for social science research, will empirical study help in patenting?
I already answered this for.
So it has to have technology.
Yes. Technological intervention is essential.
Yes. We've got Dr. Vishweshwar, who's asking, most of us in this, he says, Sairam, good evening. Most of us in this webinar academicians, a lot of pressure is on us to publish papers rather than filing patents, as patent filing is time-taking process with monetary investment involved. How do we overcome this? See,
almost all the organizations in our country, they are having some kind of administrative setups being established in their organization. So maybe at a college or a university, you don't worry for the financial this thing because they have a team which handles all these things. So you have to just approach your IP cell which is there. So they will take care of the attorney and all the monetary expenses which are required. So I don't think, filing a patent is a difficult task now.
Thank you, Anilji. I'm going to do rapid fire question and request you for rapid fire answering for the rest of them that are there. So Dr. Sanjay Kumar Pandey is saying, do I need a prototype of my invention when I apply for a patent?
Patent office doesn't ask for a prototype, but you must have it. That's my answer. You need not to submit it before patent office, but you can't file a patent for something which you doesn't have. So ideally you must have it, but patent office will not ask.
Thank you. There's Dr. Lal, there's Lakhan Lal Vishwakarma ji is saying, जनजाति द्वारा उपयोगित ethnomedicine को patent कैसे किया जा सकता है? How can you patent ethnomedicine?
देखिए, ये जो मेडिसिन की बात आप कर रहे हैं, ओके, ये इसको जो एसेंशियल रिक्वायरमेंट्स हैं पेटेंट की, वो फुलफिल करनी पड़ेंगे. ओके, तो जैसे हमने बताया वो नोवेलिटी, नॉन ऑब्वियसनेस, इंडस्ट्रियल एप्लीकेबिलिटी, वो सारी चीज़ें होनी चाहिए. उसके साथ साथ उस सेक्शन 3 में फॉल ना करें. तो मैंने आपको बताया सेक्शन 3 में एक ट्रेडिशनल नॉलेज का भी क्लॉज है. तो अगर आपकी जो ये दवाई है विच डजंट fall under that category, then you will get patent. Okay, so बहुत मुश्किल नहीं है. In case your दवाई is innovative and it fulfill all the criteria, then definitely you will get a patent over it.
Thank you. We've got again Dr. Lanka Sujata ji who's saying, sir, any property of an organism is identified for the first time in it, but it is already identified in other organisms. Can that be filed for a patent? See, discovery is different from innovation. Okay, identification of something which already exists in nature doesn't, it doesn't qualify, prima facie, until or unless there is, some kind of technological skills put in. So there are certain categories or case laws hain kafi, you can see the law with regard to your product, which since you have not disclosed the product, so ek exact answer dena thoda mushkil ho jayega, but still this is the law which I told you. I would now also, there are a few more questions, but I'll unmute some of the participants because they've been holding up the hand for a long time. But I'll request you to keep the formula of this rapid question round. So Dr. Vishwanath Kaleji, could you kindly ask your questions in a rapid fire round type? Dr. Vishwanath Kale? Sorry.
Am I audible?
Yes, please.
Okay. Similar to that literary question, if I'm having copyright over that copyright literary material, if someone is using it and making it some instrument, what you are talking about, then is it compulsory for him to take my permission? And how it is that means how the organization take note of this, and how can I know that my work is being used?
See, when we talk about copyrights, so there are
Thank you.
certain rights which I discussed. So those rights include right to restrain the others from making a derivative work. Okay. और उसमें एक आपको मैंने बताया था कि adaptation is also prohibited without your authorization. Okay. So in case you have a literary work, okay, आपने कोई novel लिखा है, you have written a novel and someone is creating a movie out of it. So it's an adaptation under law, and that person has to seek authorization from you. Okay. So in case that authorization is not in place, there is an infringement, and you can proceed ahead as per law. Okay, you can file a suit of infringement under the court of law, asking the damages and the compensation also. In fact, there is penal provisions also, which you can plead.
Thank you. Ajay Kumar Sardarji, would you like to kindly ask your question?
Hello.
Yes,
Yes,
please.
So can a proprietor of a registered design can protect his design under the Copyright Act as well?
See, yes, I got your question. See, the right, you have a design registered. Okay. So let us take an example. You have a bottle which has a unique design. Okay. So that design, that feature of design is protected under the designs law. Okay. Now you're saying that you have a picture of that bottle also, which you have registered as a copyright. Okay. And now you are saying that you have both rights with you, and if case somebody violates the rights, whether you can proceed ahead under both laws, then the answer is yes. Okay. But if you see section 15, okay, of copyright law, Copyright Act of 1957, it says in case there is a subject matter, okay, which was capable of being registered under Design Act, okay, but you didn't register. In that scenario, in case you make more than 50 copies of that item, okay, then you will lose the design right, copyright also. Okay. तो in case technically इसका आंसर ये है कि parallelly you cannot have rights in both. Okay. So you have to decide कि आपको copyright रखना है, और आप समझिए the spirit of copyright is artistic in nature. Okay. It supports the authors, okay, and the artists. तो उसकी वजह से उसका जो प्रोटेक्शन का ड्यूरेशन है वो भी ज्यादा है. बट व्हेन यू टॉक अबाउट डिजाइन लॉ, इट इज सपोर्टिंग द कमर्शियल एक्टिविटी. दैट्स द रीजन यू हैव टू शिफ्ट फ्रॉम कॉपीराइट लॉ टू डिजाइन लॉ, और उसका ड्यूरेशन देन इट विल गेट रिड्यूस्ड बिकॉज यू आर एक्सप्लॉइटिंग इट कमर्शियली. ठीक है. तो आपको वो सेक्शन 15 को एक बार ढंग से देख लेना है, और आपको ये डिसाइड करना है कि अगर वो रजिस्टर हो सकता था डिजाइन में भी, तो आपको वो डिजाइन में रजिस्टर करना है. बट द मोमेंट यू रजिस्टर देयर एंड मेक मोर देन 50 कॉपीज, आपका कॉपीराइट लूज हो जाएगा. ओके. तो फिर आपके पास एक ही राइट बचेगा, आप डिजाइन्स में जा सकते हैं. इन केस आपने 50 से कम कॉपीज बनाई हैं तो आपके राइट्स दोनों में हैं. यू कैन प्रोसीड अहेड इन बोथ द लॉज. ओके. आई होप आई आंसर्ड योर क्वेश्चन.
So we have Rajesh Rajesh ji, who's got his hands up. I'll just unmute you. Yes, Rajesh ji.
Hello, am I
Yes.
audible?
Yes, Rajesh ji.
Sir, thank you for the very good lecture. Let me ask you a question, the contemporary question regarding the social media. suppose I'm invited for a lecture, and that is paid lecture, and that host recorded that video, and who has the right to claim that video?
See, if you see the law, there are two types of contracts. Okay. One is contract of service and one is contract for service. Okay. So one has a control. Okay. So like in case of employee and employer relationship, the agreement is different. But in case that work is outsourced to you, you have been paid for that lecture, then the nature is different. Okay. So in that scenario, since you are being paid, so the rights ideally will vest in the person who has made the investment for that lecture, until or unless there is an agreement to the contrary. Okay. So in case you have signed an agreement which says something else, then that will exist. But normally the rights, they vest in the person who has affected that work or made that payment. Okay. अब इसमें जो rights हैं वो होंगे the person who has paid for it. But since you have delivered a lecture, okay, and that lecture has certain elements, okay, and one of the element is the act of performance. Okay. एक ही लेक्चर 4 प्रोफेसर्स डिफरेंटली देते हैं. Okay. And therein, I mean, that is the point wherein the quality of performance come in. Okay. So as I told you, there are certain benefits. पहले एक monetary benefit होता था, that is with the person who has paid you. Then you have moral rights which are with you. Then we have neighboring rights. Okay. तो neighboring rights में performance is one of the right which is attached. Okay. So the ownership of the lecture remains with the person, but you have a right of performance. Okay. और आपके moral rights भी रहेंगे, where you can claim the attribution कि ये lecture मैंने दिया है. You can claim कि इसमें कोई छेड़छाड़ ना हो, in case there is some destruction or mutilation to that work. So you can claim, I mean, you can restrain that party under performance right. Okay. I hope I answered your question. So
Okay, sir, thank you.
These are two separate rights. और अगर ये rights उनको लेने हैं जो उन्होंने पे किया है आपको, then he has to have an agreement stating that I take the right of performance also. ठीक है.
Okay.
तो ये दो categories हैं that you have to consider. But overall right जो है that is with the person who has made the investment.
Okay, thank you.
Thank you. Any other question? You are mute, ma'am.
Sorry, there are about 4 to 5, about 6 questions or so that are there. Would you like to answer them? It's 5:30, or would you like them to send it to you via email and you would respond to them individually?
I will prefer to answer them through email because we have, I mean, some engagement
coming up.
Yeah,
Something
at
else
5.
coming up. Yes.
Yes.
So
yes.
I really request to be excused, by all those who have raised their questions and raised their hands. Kindly understand a shortage of time on this, but thank you very much. Anilji, could you please share your email address so that all those, because they're very good questions and these are very relevant questions for all the researchers, all the academicians here.
Sure, ma'am. I'm just typing my email ID.
Yes, please. Yes, please.
at-
So if you could please, yes. In the meanwhile, I'll just like to remind everybody that tomorrow and day after we don't have any classes. We will have the next session only on Monday, again 4 to 5, and then up to 5:30 with questions. So Monday, that's 20th, 21st, and 22nd. On 22nd, there will be a little bit of a presentation, as Vishwajananji said in the beginning, and there will be the assessment. And we'd like to also just mention that the certificates will only be given to those who are attempting the questions and who are scoring above a certain mark will get a greater recognition, but otherwise it will only be for those who are attempting those questions, because we have about almost 2,000 registrations, of which only about 10% are here, a little more, maybe 15% are here. So attendance in that sense is mandatory because only then you'll be able to answer the questions adequately. So kindly encourage your colleagues to take this opportunity. It's a very special opportunity to have this interaction. So I think we'll stop here, Anirji, with your permission.
Sure, ma'am. Thank you
And
very
with the
much.
permission of participants, we'll just end with a small mantra and we'll close here. Om Loka Samasta Sukhino Bhavantu. Loka Samasta Sukhino Bhavantu. Loka Samasta Sukhino Bhavantu. Om Shanti Shanti Shanti. Thank you very much and have a very good weekend. Thank you very much to everybody too. Thank you very
Thank
much.
you, everyone. Namaskar, ma'am.
Namaste.